Hey everybody, Winnie Zhao, and welcome back to another installment of Lawyers Rock. So one of the hot topics in entertainment today is, what's up with China? There's a certain amount of mystery and intrigue associated with the topic. It's exotic and appealing because up until recently, Hollywood knew very little about entertainment in China, except for the fact that China has pirated $9 billion a year in movies, music, and software. Both American and Chinese companies are interested in co-financing and making content, but there are still several barriers to truly embracing Chinese culture in the realm of entertainment. Several factors can make this a very difficult area to navigate. There is a language barrier, cultural differences, the political landscape makes it very different, and the remoteness of China itself. Our goal today is to discuss two main areas of intellectual property rights that apply to US-based companies: copyright and trademark. We want to learn today about the creation, enforcement, and protection of these intellectual property rights because these have the greatest effect on United States-based entertainment companies. First, we'll discuss copyright. China's copyright law was established in 1990 and amended in October 2001. Registration of a new copyright is protected by the Copyright Protection Center of China, the CPCC. I'm going to be giving you several acronyms for various offices throughout this presentation because China uses a lot of acronyms and you'll find that these titles are quite lengthy. So, similar to the United States, copyright in China protects the following intellectual property works: written works, oral, musical, and dramatic works, artistic and architectural, photographic, cinema, computer software, and more. Unlike other areas of intellectual property law such as trademark or patent, copyrighted works do not require copyright registration in order to be protected. However, the U.S. Embassy of Beijing advises that copyright owners may wish to register their works with the National Copyright Administration of China, the NCAC, in order to establish and enforce ownership of their copyrights. Copyrighted works are protected under Chinese law for a term of 50 years. Foreign entities, first published outside of China, so that would be US-based companies that have pre-existing copyrights. These copyrights are protected by international copyright conventions or bilateral agreements between foreign nations and the country of China. China has ratified two in particular that I'll highlight: the World Intellectual Property Organization Convention, WIPO, and that was since 1980, and the Berne Convention for the Protection of Literary and Artistic Works since 1992. To register a copyright, an applicant must complete an application form and mail the application materials to the CPCC. Your application package should include documents such as the identification of the applicant, documents showing your copyright ownership, samples, as well as a description of the work. The CPCC will review your application and determine the cost, which generally will range from about 100 to 2,000 renminbi. That's the equivalent of about 14 to 299 US dollars. After that fee is paid, the applicant will receive a receipt of payment and subsequent notice that the application has been accepted. This generally takes about 30 days and results in, if successful, results in a copyright registration certificate issued by the CPCC. There's two main ways to enforce a copyright. You can take the administrative path or the judicial path. For administrative enforcement of copyright, it's handled by the NCAC, the National Copyright Administration of China. This is usually a faster and cheaper route than seeking judicial enforcement, but there's pros and cons. So on one hand, if you take this route, you can order infringers to stop their illegal activities, you can confiscate illegal goods, and issue fines. However, the NCAC cannot issue damages for unlawful copyright infringement. So if monetary damages is what you're seeking, then you might think about judicial enforcement of your copyright in China. The good news is that judicial enforcement is becoming more accessible. In 2015, China implemented the first 3 intellectual property courts. We've got one in Beijing, Shanghai, and one in Guangzhou. The aim is to improve the quality and speed of court proceedings involving intellectual property rights. The next topic we're going to discuss is trademark. China's trademark law was first adopted in 1982 and was subsequently revised in 1993 and 2001. A trademark is a unique name or symbol that brands use to tell consumers that a particular good or service comes from a particular producer. In 2014, China implemented a new trademark law. The China Trademark Office, the CTO, now states that an applicant can register for their trademark online in, quote, 5 easy steps. The cost for this is $499 for one mark under one classification, and the turnaround time is 1 year. So China applies a first-to-file system. The CTO will approve the application, which is first filed. This can be problematic for a US-based company that has a trademark protected in the US if it leaks to China. If a Chinese party registers that trademark first, then problems can ensue between the rightful owner and the entity that beat the applicant in the race to the China Trademark Office. The U.S. Embassy in Beijing recommends that foreign companies register internet domain names as well as Chinese language versions of their trademarks. One interesting example is Air Jordan. So Michael Jordan's brand, Jordan, is phonetically registered in China under the transliteration in Mandarin, Qiaodan. This type of issue where a U.S. company has a Chinese-based company infringing on their trademark can last for many years. So when the U.S. Embassy is saying that you should register the transliteration of your brand into Chinese, that's probably not a bad idea. Enforcement of a trademark can be administrative or judicial. For administrative enforcement, these actions are commenced with the Administration of Industry and Commerce in China. That's a mouthful. That's the AIC. The AIC office performs a variety of roles in business administration, which some people find it's quite difficult to navigate. Administrative enforcement is a practical route since the AIC can investigate your case and seize any infringing goods. It also has the power to levy a fine. The second route is judicial enforcement. Since some parties find that the Chinese AIC can be a difficult system to navigate, judicial enforcement is preferable if a party wishes to obtain compensation for the infringement. So, similarly to copyright, this gives the aggrieved party an ability to obtain monetary damages if that's what you're after. So in conclusion, we've barely scratched the surface here with these types of intellectual property rights. There's a lot more information that we have yet to cover, but we hope we can help you highlight the importance of protecting your intellectual property rights overseas as a US-based company that's looking to expand. Please let us know if you have any questions, and we'll look forward to seeing you again next time. Winnie Zhao signing off, Lawyers Rock.